Ms. Keen-Warren, can you please raise your right hand as best you can? You swear to tell the truth, the whole truth, nothing but truth, to help you God?
Yeah.
Okay, thank you. For the purposes of the plea, if you can pull your mask down, I appreciate that. Thank you. Thank you. All right. Can you do you understand read and write English?
Yes.
And are you under the influence of alcohol or drugs?
No, sir.
Have you ever been treated for a mental or emotional condition?
No, sir.
Has anyone forced you to take this plea today?
No, sir.
Has anyone promised or anything to get you to take this plea today?
No, sir.
All right. Please listen carefully to the prosecutor, Mr. Scott, outline the terms of your plea.
Yes, Judge. Case number 2017 CF 8722, State of Florida versus Sheila Keen-Warren. The state of Florida and the defendant agreed to the following plea in the circuit court. In the aforesaid case number, Ms. Keen-Warren, the defendant herein, will agree to withdraw her previously entered plea of not guilty and her plea of guilty to the following charges: to count 1, guilty of second-degree murder, a lesser included crime. The defendant acknowledges as part of the plea, the plea to the foregoing charge is willful and voluntary. She acknowledges she's read and understands the charges filed against her, the charge filed against her, the elements of the charge, and any potential defenses thereto. The defendant is pleading guilty because she's guilty, and a factual basis does exist for the crime that a jury could find sufficient to prove the charge beyond a reasonable doubt. The defendant understands if the court accepts the plea, the defendant will give up her rights to the trial, which she would have the following rights: to have a jury determine whether or not she's guilty or not, to hear witnesses testify, and to have her lawyers question and cross-examine them, to subpoena and present witnesses and items of evidence in her defense, to present any defense she might have to the jury, to testify or to remain silent, to require the state of Florida to prove her guilt by admissible evidence beyond a reasonable doubt. The defendant further understands she gives it the right to appeal all matters except the legality of the sentence or the court's authority to hear this case. She agrees that her lawyers who are present here in court with her have explained to her what an appeal is. The defendant agrees that she's read the charging document, the indictment in this case, and understands the charge to which she is pleading. It is a lesser included crime. The defendant agrees that her lawyers have explained to her the maximum penalties for the crime charged and the essential elements of the crimes and any possible defenses, as well as the crime to which she is pleading. No one's promised the defendant anything or tried to force or coerce the defendant to enter the plea. She is entering this plea freely and voluntarily. Pursuant to the 1990 rule of Florida Rule of Criminal Procedure 3.988, the court can impose a life sentence in the Department of Corrections that would be with parole pursuant to the 1990 Florida statutes. And the defendant understands that the ranges on the score sheet for Rule 3.988 for second-degree murder include a recommended sentencing range of 12 to 17 years in the Department of Corrections, a permissive sentencing range between 7 and 22 years in the Department of Corrections. No promises have been made to her regarding any gain time or the length of time she will actually serve. The defendant agrees that following the acceptance of her guilty plea, the court shall adjudicate her guilty of second-degree murder, sentence her to the bottom of the guidelines, 12 years in the Department of Corrections. She agrees that she has credit for the time she was placed into custody, September the 26th of 2017, up to and including today, April the 25th of 2023, 2,039 days times 2,039 days credit for time served. She waives any additional claim to any additional time served. She acknowledges that she's not under the influence of drugs, alcohol, or medication at the time she entered in this plea. She's not suffering from any mental problems at the time, which affects her understanding of this plea. And she understands that and acknowledges she has voluntarily signed this plea. It's not been coerced in any way. The defendant agrees she's read every word of this written plea, or her lawyers have read them to her. And she's discussed this written plea with her lawyers, fully understands it. She is fully satisfied with the lawyers have handled all the work they've done in this case, which has been extensive. The defendant understands and her attorneys explained to her if she is not a United States citizen, a plea of guilty would subject her to deportation according to the law and regulation of the United States Department of Homeland Security. The lawyers are not aware of any physical evidence containing DNA known that could exonerate the defendant, or any that has not been thoroughly disclosed in discovery or explored by all lawyers in this case. The defendant understands she has the right to appeal the judgment of the sentence of the court within 30 days, and an attorney would be appointed to her if she could not afford an attorney. John, which a factual basis?
in a little bit.
Okay.
Ms. Keen-Warren, did you hear all that?
Yes, sir.
And are you in full agreement with all those terms?
Yes, sir.
Mr. Scott, before we proceed further, has there been approval by the victim's family?
Yes, yes. And I've spoken with Mr. Aaron's, Mr. Joe Aaron's. I believe he is on the Zoom,
Okay.
although I don't, I
I'll
have.
check on that right now and make sure that if that's the case, that he's,
Yeah, I know he was attempting to get on, but I can tell this court that I spoke with Mr. Aaron's extensively over the past 2 weeks and then on last evening specifically. And he is 100% in agreement with this plea. I just am not seeing him on the Zoom.
well, why don't we continue on and hopefully.
Let me send him a text.
Okay, all right.
My assistants are working on that.
Okay, so like I said, at some point in time, I did want to give him the opportunity to be heard if
Sure.
he. What you've told me though, in
That-
essence, is that he's on board in acceptance of this resolution, correct?
Yes, yes. And we spoke last night right around 8 o'clock and he's in agreement with this plea.
All right. All right,
Yep.
so again, Ms. Keen-Warren, you heard Mr. Scott outline all those terms and you're in agreement with those, right?
Yes, sir.
There's a document I have in front of me. It's 4 pages long. It's called Plea in Circuit Court. You recognize that document?
Yes, sir.
Okay. You had a chance to review all the details of that document with your lawyers,
Yes.
and there's a signature on page 3. Above where it says acknowledgement of counsel, it says Sheila Keen-Warren, defendant. Is that your signature?
Yes, sir.
You placed it there after careful reviewing all the terms with your lawyers, correct?
Yes.
And are you satisfied with all their counsel advice to you in this case?
Yes.
Have they done everything you've asked of her? Excuse me, have they done everything they've asked of you? Have they done everything you've asked of them? Yes? Okay. All right. Now listen carefully to Mr. Scott outline the factual basis for your plea.
Yes, Judge. If this case were to proceed to jury trial, the state would present evidence and prove the following facts to a jury beyond a reasonable doubt. That on or about May the 26th of 1990, the defendant was responsible for the death of Marlene Warren at her home at 15470 Takeoff Place in Wellington. Said act that caused the death of Marlene Warren being imminently dangerous and demonstrating a depraved mind without premeditated and designed intent to kill. The state would present evidence and witnesses, civilian witnesses from inside of the home who would testify before this court that they observed a clown come to the front door, hand Miss Marlene Warren balloons and flowers before shooting her in the face. That caused her death. They would testify that they then saw the clown drive away in what they would describe as a white Chrysler LeBaron. The state would present both civilian and law enforcement witnesses that would testify to locating a white Chrysler LeBaron approximately 4 days after the murder in a Winn-Dixie parking lot. Said car contained trace evidence, including what some officers observed as long brown human hairs and what they described as artificial orange-like fibers. That same day, law enforcement executed a lawful search warrant of the defendant's apartment and observed, some law enforcement observed orange artificial fibers that appeared to be similar in appearance to the evidence located in the white LeBaron. At the time of this search warrant and encounter with the defendant, law enforcement would testify that the defendant's hair was long and brown and appeared to be consistent with some of the hairs located in the LeBaron. Civilian witnesses would also testify that the white LeBaron located at the Winn-Dixie parking lot was in the possession of a company called A Bargain Motors for weeks prior to the murder. A Bargain Motors at the time was a used car and rental business located in downtown West Palm Beach. At the time, it was owned and operated by a Mr. Michael Warren, who was at the time the deceased victim's husband. At that time, the defendant, Ms. Keen-Warren, Ms. Keen at the time was a repossession agent operating her own company, repossessing vehicles, but did repossess cars for A Bargain Motors and Michael Warren. There would be civilian witnesses that would testify before this court to observing the defendant and Mr. Michael Warren together at several points in the months leading up to the murder. Civilian witnesses would testify that some of the times that they were together, they were in the same white Chrysler LeBaron. Some of the times that they were observed together, they were going in and out of the defendant's apartment. Some neighbors would testify to that. Some civilian witnesses would also testify to intimate interactions between the defendant and Michael Warren. Days after the murder, witnesses from a local costume shop, dance studio called the Spotlight Capizio would testify and state that a few days prior to the murder, a woman came into the shop and purchased a clown outfit, including a wig, a costume, makeup, however, with no shoes. Those two witnesses would positively identify the defendant from a photo array, two photo arrays from back in 1990. They told law enforcement at the time and would testify before this court that the person identified in the photo array was the person who purchased a clown costume with makeup approximately 2 days prior to the murder. The person in the photo arrays would be identifiable as the defendant in this case, Ms. Warren, Sheila Keen-Warren. Upon a search of the defendant's apartment, no such costume was located. Upon speaking with the defendant in this case, she denied ever purchasing or wearing or owning a clown costume. A civilian witness from a local public supermarket would testify and describe a person with some similar features to the defendant at the time, purchasing a similar balloon and flower arrangement the morning of the murder. The civilian described the similar features, however, could not at the time make out a definitive identification. Subsequent to the murder of Ms. Warren, the evidence would show that, and the state would present the witnesses that the defendant and Michael Warren subsequently owned a restaurant in Tennessee called the Purple Cow. Documentation evidence would be presented to show that the defendant would marry Michael Warren, the deceased husband, in August of 2002, and the two would live together in Abington, Virginia until her arrest in 2017. The state would submit the totality of the facts and circumstances, would lead a jury to find her guilty of the crime. All of the events outside of the Tennessee facts and Abington, Virginia did occur in Palm Beach County, Florida.
Ms. Keen-Warren, did you hear all that?
Yes, sir.
And do you agree with that factual basis?
Yes.
There's a two-page document called the Waiver of Rights Sheet, and it's got 16 paragraphs on it. And I know Mr. Scott has touched on a lot of the rights you're waiving, but do you recognize this two-page document?
Yes, sir.
Okay, and those are your initials down the left side of all the paragraphs?
Yes,
You just sign the second page?
yes, sir.
You realize, Ms. Keen-Warren, that those rights are all set forth in that two-page document. They include all the rights you have that you're giving up by entrance of this plea of guilty today. You understand that?
Yes,
Okay. For instance, you had a right to have a trial, right to require the government for the charges against you beyond a reasonable doubt. That's not happening. You could have testified. You could have remained silent. You could have had your lawyers challenge the evidence in the case. You could have appealed the case if you were convicted. That's not going to happen because you're waiving all the rights that are set forth in that two-page document. You understand that?
yes,
And were your lawyers available to you to explain all those rights to you before you initially signed?
yes.
You need to talk to them anymore about any of those rights you're waiving.
No, sir.
Okay. And you realize that is this a first felony conviction?
Yes, Judge.
Okay. Have your lawyers also discussed with you the significance of becoming a convicted felon?
Yes, sir.
You understand as a convicted felon, you lose certain civil rights, including the right to vote. Okay, you also understand as a convicted felon, you lose the right to legally carry a firearm in the state of Florida.
Yes,
Also, as a convicted felon, also it makes it very difficult for one to get good employment. Do you understand that?
yes,
If you're not a U.S. citizen, you could be deported for this. Do you understand that?
yes.
Mr. Scott, I know you touched on this, but I ask you again. Are you aware of any physical evidence which DNA may exonerate the defendant?
No, sir.
The defendant, Mr. Rosenfeld, have you read the discovery and, well, actually, we asked Ms. Keen-Warren, have you read the discovery and are you aware of any physical evidence which DNA testing may exonerate you?
No, sir.
I find that, and do you know of any physical evidence for which DNA testing may exonerate you?
No, sir.
I find that based upon these representation, no physical evidence exists for which DNA may exonerate the defendant, Ms. Keen-Warren. You still have a right to appeal the legality of the sentence. An attorney can be appointed if you cannot afford one. The 4-page police sheet that you signed, does that outline the complete agreement between you and the government? this plea sheet? Is that the complete agreement between you and the government?
Yes, sir.
Okay. Is there anything else that you're relying upon in making this decision that's not specifically included on this document?
No, sir.
You realize after you leave the room today, you can't come back in here and withdraw this plea.
Yes, sir.
You understand you're bound by its terms?
Yes.
Also, when you're done with your sentence, do you realize this particular conviction could be used to enhance a future sentence that you get if you get in trouble again down the road?
Yes, sir.
All right. So before we go ahead with a change of plea, is the son available?
He is, Judge. He's actually right, well, on the screen above the witness stand. He's actually right next to you.
Okay.
And he's been able to hear. I got a note from my investigator. He's been able to hear everything.
Does he want to make a statement at all?
Mr. Aarons, do you wish to make any type of statement?
You got to press the unmute button. Sir, you need to press the unmute button if you'd like.
Go ahead and unmute, sir.
Good morning. Good afternoon, sir.
Can you hear me now?
And sir, can you tell us your name, please?
Yes,
What's your name, sir?
my name is Joseph Aarons.
Okay. And what's your relationship to the victim in this case?
That was my mother.
And would you like to address the court at this time?
The only thing I want to say is all through this trial, I didn't see any remorse. And that's all I have to say.
Has Mr. Scott reviewed with you the plea, and are you in agreement with the terms?
Yes, I am.
Thank you, sir. If you have anything else that you wanted to say, this is your opportunity if you'd like, sir.
God be with her.
Thank you, sir. All right. You can press the mute button if you'd like, sir. Before we do change of plea, is there anything else, Ms. Keen-Warren, you wanted to say this time? Okay, all right. Having heard everything we've discussed, Ms. Keen-Warren, do you still wish to plead guilty and have me impose the sentence as outlined in the plea agreement?
Yes.
Okay. Mr. Rosenfeld, do you want to change your plea, please?
Yes, Your Honor. At this time, Ms. Keen-Warren withdraws her previously entered plea and her plea of guilty as outlined in the plea agreement.
Ms. Keen-Warren, I find that you have made a knowingly voluntary and intelligent waiver of your rights. You know the charges against you and appreciate the consequences of the plea. And by the way, I didn't ask you this. Do you agree with the amount of credit that was mentioned earlier, and it's also signed off on the sheet, which is 2,039 days credit?
Yes, sir.
And you realize by agreeing to the number 2039, you're waiving any affirmative right to appeal the number 2039 as far as your credit is concerned. Understand that?
Yes.
Again, I find you made a knowing, voluntary, and intelligent waiver of your rights. There's a factual basis for the plea. I believe that Mr. Keen-Warren knows the charges against and appreciate the consequences of the plea. I accept the plea and sentence according to the terms that are set out in the plea sheet. And there'll be adjudication. PSI is waived. Adjudication on also count one, right?
Count one, second degree murder, sir.
And second degree murder. And with credit for 2,039 days, the defendant affirmatively waives any right to affirmatively challenge the number 2039 as far as the credit is concerned. And as far as court costs are concerned, judgment for the court costs?
If she could pay it a year after release.
Year after release on court costs. Anything else from the other side?
Nothing from the state.
Okay, and again, I sentence her according to all the terms that are set forth on the plea documents as well. So good luck to y'all.
Thank you.
Thank you, Your Honor.
Or being recessed.